So what is the test for bias? It is called the Reasonable Apprehension of Bias Test, and it was most recently described in the Supreme Court of Canada case in 2015 of Yukon Francophone School Board and Yukon Territory. And the test reads, whether a reasonable informed person with knowledge of all the relevant circumstances, viewing the matter realistically and practically, would conclude that the judge's conduct gives rise to a reasonable apprehension of bias. I've highlighted a few words here from this test, mainly a reasonable person who is informed of the relevant circumstances and who has viewed the matter realistically and practically. So please note that the reasonable observer or reasonable informed person in this test is not the litigant raising the issue of bias. It essentially does not matter what the litigant believes. The court looks at a sort of hypothetical third-party observer and imagines that this is a reasonable person who holds a reasonable belief of whether bias exists or not. So the word reasonable connotes an objective standard within this test. That is two things. So this hypothetical person must themselves be reasonable, as in someone who can view the matter realistically, practically, and who has thought the matter through. They don't just have a gut reaction to it. They've taken time to consider all the evidence and all the necessary factors. And the apprehension of bias must also be reasonable in the specific context of the case. So a reasonable person is informed of, like I said, the facts of the case and the social reality forming the background of the case. They're also aware of the duty of impartiality that judges swear to uphold. So they're knowledgeable of court proceedings and they're knowledgeable about all the specific factors that underpin the case. The reasonable person must also hold more than a mere suspicion of bias. Like I was saying, they must hold more than just a hunch or a gut feeling or a fleeting sort of thought that bias existed at first instance. After considering all the relevant factors, they must hold an honest belief that a real likelihood of bias exists. However, actual bias by the judge doesn't need to be shown. No one can really understand what's going on in a judge's head. We can't read minds. So all that matters is that it is shown, it is proven that a reasonable observer would conclude that a judge appears to be biased. Not that the judge, actually acted with bias and held a certain mental state that represented this bias. That's a bit of an overreach. So the evidentiary burden for the reasonable apprehension of bias test, it is a very high burden. Some cases have described it as an extremely high burden, simply because the presumption of impartiality, it's a very hard principle to sort of unseat, given that judges are viewed by the court and by the public as upstanding figures who take their duties and their roles seriously. It is simply presumed that they are impartial because this is one of their duties. The test for reasonable apprehension of bias, it's not a one-size-fits-all approach. There are no generalizations, essentially. Proving a reasonable apprehension of bias and interpreting it is an entirely case-specific endeavor. And parties should be aware that the party asserting bias must prove the bias. It's not enough to simply put up one's hand and say, I feel this is bias, therefore, court, do something about it. It must be, the evidence supporting this belief must be shown in the evidentiary record. So things like hearsay, if a judge looks, if a party feels that a judge, has been giving them dirty glances, let's say, that's not enough to cut it because that won't make it into the evidentiary record. There needs to be some sort of a trail, a paper trail, or an evidentiary trail for the party asserting that bias exists to point to and show clearly. And lastly, the evidentiary record as a whole is considered. So even if halfway through the trial the judge had, a 2-minute outburst towards a party or their lawyer, this is not all that a reviewing court, let's say an appellate court, will examine. The appellate court will look at this one specific incident, or perhaps there's several, and will hold these up against the context of the entire evidentiary record and the entirety of the proceedings, and sort of do a balancing act of, was this incident, did this color the rest of the trial? Did it taint the rest of the trial with bias, or was it just a one-off incident that, a reasonable third-party observer could simply excuse as, human behavior by a judge?